Welcome to another episode of the Edfields Podcast, your everyday law podcast. We are going to be talking about a very interesting topic, a topic that's interesting to everyone listening today. And it's going to be about the law in the markets. So we are going to talk about sale of goods in general. And you are either a business person, if you are listening or you're watching, you're either a business person or you have bought something before. So you should be very interested in this. And I have with me Jasmin, Richard, and Prince. And I am Alberta, your host for today. So you're all welcome.
Thank you.
Thank you.
So we are going to be talking about a contract. When we talk about contracts for the sale of goods, what does it constitute? Does it have to be written? If I say I'm entering into a contract, does it have to be written? Do I have to sign something? Does it have to be up to $1 million before we can call it a contract for sale? Jasmine.
Well, a contract for sale is an agreement between two persons or more persons where there is an agreement to purchase something, a property, it could be anything, for some consideration or some value. All right. And there are a few things that need to be, that you must look out for when you're going into a contract. Now, you don't necessarily have to go into a contract because it's a multi-million dollar transaction. You could even go into a contract, even if it's $1. There must be some consideration. And the consideration can be in money or it could be in kind as well.
Okay. So, Richard, do we have to write something down? So, my question is in two parts. If I'm entering into a contract for, let's say, $1, is it something I can write down? Am I permitted to write it down? Or if it is any other contract, do I have to write it down? Or if I meet Prince and I tell Prince, I have a watch, I want to sell it to you. Prince says, okay, how much is it? We talk about it and he pays and we are done. Is that a contract? Or because it's not written, it's not recognized as a contract?
Fundamentally, the decision to do business, as people understand it, doesn't necessarily have to be in writing. So once the parties are clear in their minds as to what they are agreeing on, at what price, for what product, a contract could be deemed to have been either executed or formed between the parties. But largely because there's also the anticipation that sometimes people don't keep their words. And then you'll be called upon to prove what we've agreed on. That is why generally the law expects that once there is such an agreement between parties, it should be evidence in writing, so that if there is a need for us to show that truly it was A that we agreed on for the price of B, it is in writing. It is not up to you or me whether we agree on what we actually agreed on prior to the formation of the contract. So whether it's in writing or not, we'll still make it a contract. But because of that anticipation and that risk you run for persons who you contract with not keeping their words, and then there will be a time for resolution of any disputes that may arise, it is always advisable that such arrangements must be evidenced in writing and also largely witnessed by a third party. And there are clear procedures around what writing will mean. Writing, we mean ink. So either you are writing with pen, or today everybody uses computers to type or is typed out, so that we are clear that this is what has been written, this is what the parties agree to. But sometimes as well, you see, it's not in every contracting position that you have parties that are of equal understanding. Yes. So there are times that you may be contracting with an illiterate. So the defense or the excuse comes up to say that when you brought the contract, you drafted it, I didn't understand what it was, and I was forced to sign it. So largely when those things are evidence in writing, the expectation is that either you are explaining to the person in the language the person understands, or you've gotten someone who can explain it to the person, and the person will have to evidence consent and understanding of what he or she is signing to. That is why the role of witnesses are important, to attest to the fact that I saw Mr. A sign this agreement, maybe after he has been explained to him in a language he understands, and then he demonstrates that he's willing to be bound by the terms of those contracts. So legally, we call those other provisions as jurat,
Yes.
which is to show that even if you dealt with somebody who is an illiterate and do not understand law and did not understand possibly the English and the way the terms have been drafted, there was that understanding at the time he or she was signing. So largely, that will be the scope for whether it is written or it is unwritten. But for business people, most of the businesses that happen around town are businesses that happen in an oral form.
Yes.
So you go to a car garage, you have a car, you want to buy it, you bargain with the owner of the garage, you give money, he gives you the car and the papers, you are gone. There may not be any agreement signed between the parties. That situation, yes, will largely be considered as a contract, despite the fact that parties tomorrow may say that it wasn't A that we agreed on, and rather it was B, which will now be up to the court in dispute resolution instances to try to understand what really the intention or the agreement was. And a lot of times people ask that, so in that circumstance where there was no agreement, how would the court be able to tell whether A was lying or B was lying? There are several ways the court may tell. One of the ways is conduct.
Yeah.
And conduct in the sense of what was your conduct before the agreement, what was your conduct after the agreement. So the evidence of your conduct becomes a trace for whether truly you agreed to what the other person is saying or you did not agree to it. So for instance, I am a farmer, and then you said you want 10,000 bags of maize. You pay me 50 Ghana cedis, and that I should produce the maize for you. Maybe my conduct before the agreement is that I only produce 5,000 every year, and I've been doing that for the last 5 years. I only decided to produce 10,000 because you have agreed with me that you're going to buy 10,000. So if I've made the 10,000 available and you come back and say that, look, you never agreed with me that it was going to be 10,000, my conduct will demonstrate that, look, over the last 5 years, I've done only 5,000 bags every year. Why do I jump to 10,000? Excuse me to say, I'm not stupid. There should be something that should be motivating me to jump from 5,000 to 10,000. So that becomes evidence of what we have agreed orally. So those are some of the ways by which the court usually will resolve whether there is an oral agreement, and where parties are disputing, how do we arrive at who is telling the truth versus who may be disputing what has been agreed.
Okay, so I'm sure by now the viewers are realizing that you enter into contracts every single day. When you go to the market to buy your tomatoes, your pepper, and all that, they are all contracts,
Yeah.
right? Okay, so Prince, when Jasmine and Richard were talking, I heard words like consideration, I heard intention, I heard price, stuff like that. Are there any elements that will show that this is indeed a contract? What and what do we need to see that, okay, this is a contract, or even though you guys agreed on something, it is not a contract?
So now we are looking at a situation where the agreement we are talking about is reduced into writing. Yes. So because it is an agreement for the sale of goods, the first thing you should be able to identify, or the first thing you should be interested in identifying, is what exactly you are transacting on, which is a very vivid description of the good or the property we are talking about. So that in a time or in a period where there's a dispute and the person who was buying or the person who was selling is disputing what exactly was the subject matter, you can just produce that document to say, this is what you said. There have been instances where people sign agreements, for example, and then they say that I'm giving you this money to buy a car for me. That is quite vague. He can just go and buy a Vitz. Meanwhile, in your head, you are considering a Benz or something like that, and it becomes a problem. The second thing you should also look out for is what Jasmin was talking about, consideration. That is the price or the value of that property or good that you're talking about, so that you are able to put figure or you are able to put the exact value to the property. So if I say that, oh, I have this phone I am selling, and you have an intention to buy, there's supposed to be a value that you give to me in order to get this phone. And so if you are reducing it into writing, after describing what this phone is, you should be able to say that this is the amount. And normally too, I tell people that in Twi we say nipa ya boaboni. Like human beings are very, very dangerous and quite stubborn. He will sign and then tell you that he doesn't even remember the time he did. So why would you sign an agreement like that without a date? We should be able to trace to see that this contract, this agreement was signed on this day. So these are the first three that I would tell people to look out for. And then the parties involved. You should be able to have some things that would trace the agreement to you, the two who signed the agreement. So your names and then maybe your address. So these are very fundamental things when it comes to reducing a contract into writing. The others normally flow from these ones. So for example, the consideration of the price, you may be thinking about how the money is going to be paid. And that flows from the value itself. Yes. So how is it going to be paid? You are talking about delivery. How is it going to be delivered? When is it going to be delivered? These are certain obligations, and they all flow from the description, knowing exactly what's going to be delivered, and then you talk about the delivery. So I think these are a few things that people should look out for, especially when you are very consistent and very clear in your head that, okay, what I am buying, I want it to be reduced into writing. These things are supposed to appear.
Okay. I think to add to what Prince has said, I think two other elements I would look out for if it's a written document would be the capacity of even the parties who are entering into the contract. Per the laws of Ghana, you must be of an age of 21 years to be able to go into a contract, a written contract. And so I would also pay attention to that as well. The other thing is the legality of the contract. People go into contract for the sale of even illegal products.
Yeah.
And would expect the courts to determine the issues when there's a default or where an issue arises. So I would also ensure that whatever contract the parties are going into is legal in the eyes of the law.
Another dimension for the issue of capacity is the fact that you must be the owner of what you sell, or you must have authority of the owner to act on his behalf or her behalf. So when sometimes issues of capacity comes up, they may be coming up not only from the issue of the age, but issue of whether or not you were the owner or you had capacity, you had authorization from the owner to sell it. Because you cannot give that which you don't have. So so that is one inquiry any lawyer will be making. If, for instance, you engage a lawyer to do a due diligence for you as part of the purchase process, to be confirming whether or not the person who is purporting to be selling a thing to you either is the owner or has authorization from the owner to transact the business on his or her behalf. Because that is very, very important. Largely, if you don't have capacity to, or you don't own the product, you shouldn't be selling it in the first place. And then we know that there are certain principles in law that also may come to your aid.
Yeah.
Buyer without notice and all those ones. But don't get to that extent, create those complications and make the work very difficult to deal with. It's better you get some of these things sorted right from the beginning. Yeah.
There's something that's a basic thing I hear very often when it comes to contracts. We are all lawyers. When you go to law school, you hear about offer and acceptance. And I just remembered an encounter I had with an Instagram vendor. Those who sell goods online, they are also into. I mean, you also enter into contracts with them.
Yeah.
So some of them, they don't put their prices in the post. And I'm not the only one who has experienced this. Somebody has also told me about how she went into the person's DMs, asked, how much is this? And the person tells her, oh, is this price? Then before you realize, they are asking for your delivery details. You haven't, is there an acceptance there? Or so it means that if this is somebody I have bought from, and the person has my delivery details, has my number, I'll just ask, how much is this? And before you realize, I'm getting a call from a delivery guy that we have a package for you. So how does offer and acceptance play out when it comes to the entering into a contract? Because I know that there must be an offer and there must be an acceptance. How does it play out?
So an offer has to have this exactitude, like it is supposed to be that definite.
Yeah.
Okay, I am selling this phone, and then I put a price to it that if you give me 2,000 cedis, I'll give you this phone. I'm selling it. Now
That's an expensive phone. It couldn't be 2,000.
I can't say 200 because this is an iPhone. So if you give me 2,000 cedis, I'll give you this phone and you become the owner. Now, what I am doing is that I am offering this phone to you for sale. I mean, for you to purchase. So I'm offering this for sale. If you say, okay, I accept to take this phone and I'll give you 2,000. Or you say, okay, I have agreed to your terms, then that is a communication of your acceptance to the offer I made. So you can't come and give me 1,500 and say that, that is what I have. I can decide to say that, no, I won't give it to you. Immediately you say, oh, I'll give you 1,500. The 1,500 you are saying is your offer. And that's what we call counter offer. And when you do that, you cancel out my offer, and that one no more stands unless you go back to say that, okay, I've changed my mind. I want to give you the 2,000 and take the phone. And that is what some people don't understand. And the fact that someone has also displayed something will not necessarily mean that the person has offered it. So it's like you go to a supermarket, you see things displayed there, you see prices there, and then you think that there's an offer already. When you pick it and you take it to the counter, that is where you have given the offer. And then they say that, okay, give me your money and take it. Then a contract is formed. So we have to get the differences between the two. One is just an invitation that, oh, I'm inviting you to come and give me an offer. And then I will communicate my acceptance. So it's not always that the offer comes from the one who owns the property. Sometimes you, the buyer, you give the offer, and then the one who owns the property accepts it. But the two are supposed to be definite, very clear, unambiguous, so that, like I said, nipa ya boabone, so that at the end of the day, there isn't any conflict as to whether you offered or he accepted.
So from what you're saying, Prince, it means that I can go to the shop and attempt to pay for an item at the counter, and the shop can decide not to sell to me.
Yeah.
And that is, they have not accepted my offer.
Exactly.
Of purchasing
You've
that
offered
item.
and says that no. That's why some people go to certain garages. They see that the cars are displayed, no prices attached. You go, you say, now I'm scared to mention a big price. Because you say, I'll give 50,000 Ghana cedis for this A4 or the A4, and then he says that nah, you can't even buy this car with 100,000. It means that your offer that was given was not accepted. So there are situations that you make offer, and then because it's not binding on the person to accept, you say no, and that's fine.
And
It's supposed to be fine. I mean,
so that is also the reason why, for example, you can walk into a mall or a shop, then you pick the things from the shop,
Yeah.
put them in your basket, get to the counter, and when you are about to pay, or when they are, checking the stuff in, then you say, "Oh, let me put this back." There's the contract hasn't been concluded at that
Exactly.
stage. That's the reason why you can even put something back or go back and say, "Hey, I have to buy something else," and then you go
Yes.
and come back. So that is when you get to the counter. That is where the transaction actually takes place.
Yes.
So when you are buying goods, as a buyer of goods, you are looking at two things. You are looking at the quantity and the quality. So if I'm buying, let's say I order about 5 boxes of let's say soap, 5 boxes of soap. I am looking at the quality of the soap. If I have come to Prince and I say, "Prince, I want to buy 5 boxes of a particular soap," I am looking at the quality. There's a reason why I want to buy that particular soap. And there's a reason why I want to buy the quantity of that soap. So when it comes to quantity and quality, so for example, if Prince delivers 4 boxes to me, he's supposed to deliver 5. He delivers 4 boxes to me. What do I have to do? Can I reject everything? Do I have to pay for the 4 by all means? Because it's not up to the amount or the quantity that I wanted. What are the options available to me?
Well, in that situation, when it comes to quantities, if the quantity is below the amount you contracted for, you have the option of paying the difference or paying what you requested for, or paying the amount which is less, what has been brought to you. All right. You also have the option. It is not a major breach per se. So you can easily pay for what you got. If it has to do with quality, what it means is that it may not be fit for the purpose for which you require it for. In that sense, it may be a major condition for which you can nullify, reject the items, and even nullify the contract.
So, sometimes you go to shops or you are transacting with someone and they tell you that once they sell their goods to you, you can't bring it back. So it means that under the law, there are circumstances under which, even though you are telling me I can't bring it back, if it's not fit for purpose, for example, I have told you the reason why I am getting the good, and then you bring it and it's not up to standard, I can return it. Is that not so?
Yes, I mean, some of the contracts would give you a limitation period for which you are expected to return the item. Obviously, if you receive the item and you keep it for a long time and then realize after the limitation period has elapsed, and you would have issues with that because you have not, you exhausted the period of time for which you were supposed to return the goods.
Okay. So, Richard, on this note, I'm asking you for personal legal advice.
Free.
So, so imagine I buy a car, right? It's a used car. Then the car dealer brings the car to me, and then we test it. I drive around once, I drive around twice, and then the car is okay. Then he brings the car to me, and I realize that there's a problem with the engine, or let's say the AC doesn't work. I'm in the AC and then I'm sweating, or I'm noticing some things there. Meanwhile, I tested the car when he brought it, and he knew of these things, but he didn't tell me. But I have tested the car. I've brought my mechanic. He has checked and said everything is fine. Do I have can I call him and tell him the car you brought to me, that's not what I wanted, or I am bound by the contract?
To a large extent, you can, but there is a reason why there is that legal principle that buyer beware, seller beware. Because you also bear the obligation to go with your mechanic and undertake all the tests that is required to confirm that the vehicle is fit for purpose. Because largely the one who is selling will tell you all the sweet stories you want to hear. And that's acceptable. it is your responsibility as a buyer to also confirm and ensure that everything is right per what the seller is saying. So where you fail in that obligation to confirm all these things by either using your own independent mechanic, and you come back and say that the car has these major problems, largely because it's vehicle. Mechanical problems can develop anytime from use. So that becomes a question of whether or not the one who is selling has either given you a warranty for whatever period that he or she is ready to accept any, for instance, manufacturer's default or manufacturer's defect in the vehicle that you've purchased from him. If not, it will become very difficult for the seller to just accept that the AC is not functioning and it's because of his fault. So my advice would be that better go with your mechanic, agree on a period which is reasonable as a warranty period, where some of these issues, once they are major issues, you can either come back for him to either repair it or put it back into a shape that is fit for use, or there's some arrangement on some discounting in terms of if there is any balance to be paid or if there is any additional discount he want to give you. But to be able to return it fully for your money, it will be a very difficult one, because to prove that who is responsible for that challenge, particularly when you didn't also confirm at the time of purchase, will become a very critical issue to resolve. And if you're not careful, that may land you in court, and you may spend more money than the cost of the vehicle resolving that challenge.
Okay.
Yeah. So the other way around of your question is where you know Ghana and relationships, and then this thing called authoritative knowledge. So I see XY, Mr. XY, and I think that this guy has always been selling cars to people. He's a professional. He will tell you what it is. And so I don't see the need to go to his garage with my own mechanic. So I go there, I ask him, oh, I want this car for this special wedding. And then based on what he tells me, I rely on that and I buy the car he points to me. So in that regard, I have not done my own investigation. I have not done my own checks. I have relied on his advice as an expert to buy that particular car. Unless maybe it is this second hand, which ordinarily you, like Richard was saying, ordinarily you should anticipate that there might be one or two things. But because I did not do the checks, and maybe the faults that later developed was not something that I could have seen with just looking at the car. You, the seller, will be the person we will say you should have been. Beware. You should beware of those things. That your advice is what the person has based on to buy the car. So if anything happens, it's on you. So those situations also come up, especially with cars. This is a boss. This is a dealer. When whatever he says, I am going with you. Some people do that. You are the boss. Whatever you say, salute. You see.
Okay, so one last thing, Jasmin. We are almost out of time. So when it comes to exclusion clauses, so the seller is limiting liability and all that. Sometimes you take a contract and the contract is written in, let's say, font size 12, but the exclusion clause is written in font size 2. You can't even see.
It's always the case.
Yeah. So in that situation, if I know that I'm supposed to read the contract, but if I'm not able to see it visibly, will the law protect me?
Now, exclusion clauses, some say exemption clauses, or limitation clauses. They are one of the terms in a contract that are very controversial, and if you are not careful, they would usually raise issues in court. And they are many sellers, depending on who drafted the contract, would try to add certain clauses which seek to restrict the liability of another party. And so it is important that no matter how the font size is, you must pay attention to them and read them, because if it turns out that the seller is not aware of such a term and goes ahead to contract, look, I believe the court would protect you to a large extent. And so it is important. And for me, that is why I always advise, people would say Ghanaians don't like to read, or people don't like to read. So if you know that you are a kind who doesn't love to read and cannot peruse your contract, every single word, then you can get a lawyer, an independent advisor to go through and read every single word in a contract. Because if you leave out anything, it could eventually, when there's a breach, the damages that are ahead of you to pay will be sorry. And we see that every day in court.
All right. So talking about damages, what are the, apart from damages, what are some of the other reliefs that are available to maybe a buyer or a seller in case there's a breach? What are some of the things that the innocent party can ask for?
In ordinary terms, one of the options you have as a party who is suffering the breach will be to terminate the contract. So termination is a right you have. The other option you have will be to request that the party return you to your previous position. So if you had paid any money, you ask for that money to be refunded so that you go back to where you were before the contract. You could also ask the other party to specifically perform the contract. People usually think that once there is a breach, then it's only damages you are entitled to. You could also ask for specific performance. So depending on the nature of the contract, if it's an essential contract that you are still interested in, you could get a court to specifically ask the other party to perform the contract. And also, depending on the contract and the nature of relationship, you could also ask the other party, for instance, to account for profit. Maybe as a result of the contracting situation, the other party has taken an advantage and is making money and not accounting to you as a principal. You could ask the person to account for profit for that advantage the person has gotten as a result of the default on his or her part. So those options are available to any one who suffers a default or a breach of contract.
And there's also the option of claiming special damages. There are situations where, because of the person's breach, you have to spend some money. To ensure that you don't experience or you don't suffer a lot of damages. So you can, however, that you are supposed to calculate all of them. Tell the court that these are the things I had to go through or do before protecting myself. And so all those monies I want you to claim for me. And those are special damages that you can also claim in addition to what Richard said.
All right. Thank you very much. I'm sure our viewers have learned a lot. One thing I have taken away from this is that I go into contracts every single day. I'm sure on my way to work this morning, I bought Mentos in traffic. That's a contract I have entered into. So we enter into contracts every day, and we have to be mindful of the fact that there are rules that govern the contracts, whether you are aware of them or not. The rules govern it, because ignorance is no excuse. So, and for the Instagram vendors, go and read more about offer and acceptance. If somebody comes to ask you how much is something, you don't ask for the person's details. You have to conclude on the contract. The person has to accept and tell you that, okay, I am willing to buy this, before you can send the goods to the person. So thank you for spending your time with us. And don't forget to follow us on our social media platforms, the Edfields Podcast on Twitter, which is X now, and Instagram. See you next time.